All right, if you're prepping for the Queensland bar exams, you need to listen up. Amending pleadings, this isn't just some boring procedural step. No. This is a strategic battlefield. It's where cases can be won, and trust me, they can be lost. Knowing these rules, and I mean knowing them cold, is absolutely non-negotiable. So, let's break down exactly what you need to master.
So here's our game plan for today. We're going to start with the two fundamental worlds of amendment. It's like a choose-your-own-adventure, but with legal consequences. Then we'll look at how your opponent can hit back with a disallowance challenge under Rule 379. After that, we cross the Rubicon into the much scarier world after a trial date is set, governed by Rule 367. We'll unpack the massive, game-changing high court case of on risk, and then we'll finish with the one that trips up everyone, the critical, drop-dead deadlines under Rule 381.
Okay, the first thing you have to get your head around is that the entire universe of amending pleadings splits right down the middle. Everything, and I mean everything, pivots on one single document, the request for trial date. Before you file it, you live in one world with one set of rules. The moment after you file it, you are in a completely different world, and the rules have changed entirely.
So this is the great divide. This is the whole ball game right here. Before you file that request for trial date, you're living in the world of UCPR 378. That gives you some pretty broad power to amend your pleadings without even asking the court for permission, but once you file that request, you are certifying to the court that your case is ready for trial. Your freedom is gone. You are now in the world of UCPR 367, and you must get the court's permission. It's leave for any change, no matter how small.
Okay, so let's imagine you're in that first, easier world, you've made an amendment without leave, you're feeling pretty smart about it. But hold on, don't get too comfortable, because your opponent has a very specific weapon they can use to challenge you, and that weapon is found in Rule 379.
So here it is, the key point. Uniform Civil Procedure Rule 379 subsection 1. What it does is it gives your opponent a very short window, just 8 days after they're served with your amendment, to run to the court and apply to have it disallowed. That 8-day clock starts ticking the second they get that document.
And this is where things get really juicy from a legal perspective. It's a classic exam question, by the way. What arguments can your opponent actually make on a Rule 379 application? For a while, the courts were actually split on this.
So on one side, you had what's called the narrow view from a case called Reynolds. It basically said Rule 379 is only for challenging amendments that were technically valid. If the amendment was improper to begin with, you had to use a different rule, a strikeout application. But then came the broad view in Westpac v. Hughes, and this view says, hang on, that's inefficient. A disallowance application under Rule 379 should just be decided on the exact same principles as an application for leave. It avoids two separate court fights and gets right to the heart of the matter. Should this amendment be allowed or not?
And this quote right here confirms the modern approach. So here's the bottom line, your exam takeaway. The courts have landed firmly on the broader, more practical view from Westpac. An application under Rule 379 to disallow an amendment is now dealt with using the very same principles that a court would use if you were asking for leave to amend in the first place.
Right. So, what happens when you file that request for trial date? Well, as I said, you have crossed the Rubicon. There is absolutely no going back. The rules of the game are now fundamentally different, and you are completely in the hands of the court.
And here it is, the rule that governs this new world. Uniform Civil Procedure Rule 367. Let that sink in. UCPR 367. It could not be clearer. Any amendment after this point can only, and I mean only, be made with the leave of the court. Your automatic right to amend is gone. It's extinguished. You are now an applicant. You have to persuade a judge.
So, how does a judge decide whether to grant you that leave? What are they thinking about? Well, the entire playbook for this was completely rewritten by one single High Court decision. For anyone practicing civil litigation in Australia, you have to understand the world before Aon Risk and the world after. They are two totally different places.
This timeline really says it all. You've got the before times and the after times. Before 2009, we all lived in the world of JL Holdings. In that case, basically said justice between the parties was paramount. As long as you could fix any prejudice with a costs order, the amendment should probably be allowed, even if it was late. Then, bam, 2009. Aon Risk versus ANU comes down from the High Court and changes everything. The High Court said a just resolution isn't just about the two people in the courtroom, it's also about the efficient use of the court's resources and the interest of all the other litigants waiting in line for their day in court.
And this one sentence, this is the tombstone for that old just pay costs and you'll be fine attitude. The High Court made it crystal clear. You do not have a right to raise any old arguable case you can think of at any time you want just by throwing money at the other side. Delay and the waste of public resources are now front and center in the court's decision.
So, when you're on your feet arguing for leave, what do you need to show? Well, this is your practical post-Ion risk checklist drawn from cases like Hartness against Hines. Number 1, you have no entitlement. You are there to persuade. Number 2, you must explain the delay. The judge's first question will be, why are you making this application now and not 6 months ago? 3, prejudice isn't just about your opponent, it's about prejudice to the system. 4, timing is everything. An application a year from trial is a totally different beast to one made on the courthouse steps. And finally, number 5, significant delay and wasted costs are huge black marks against you.
Okay, so let's say you've done it. You navigated the minefield, you argued your case brilliantly, the judge is persuaded, and you get your order granting leave to amend. Fantastic. But don't pop the champagne just yet. There is one final, simple trap that can undo all of your hard work, and its name is Rule 381.
UCPR 381 is simple, but it is ruthless. Think of that court order giving you leave like a carton of milk. It has an expiry date. It is not an open invitation to file your amendment whenever you get around to it. If you do not file that amended document within the time specified in the order itself, it just ceases to exist.
And what if the judge doesn't specify a time in the order? Well, the rules have a default for that. You have 14 days. 14 days from the date the order was made. That's it, not a day longer.
And if you miss that deadline, oh, it's bad. The order just, poof, it's gone. It evaporates. The court registry will literally refuse to file your amended document. So to fix it, you have to go back to court, cap in hand, to make a whole new application for leave or for an extension of time. And that means more of your client's money, more delay, and a very awkward conversation with a judge who's going to want to know why you couldn't follow a simple deadline. So we'll end on this thought. In this post-Aon risk world, this is the question you must ask yourself before you even think about drafting an application to amend. It's no longer just about whether your new argument is a good one. The court will be asking a bigger question. Is this amendment a necessary step for the just and efficient resolution of this case, or is this a late, tactical move that's just wasting the time and resources of the court and everyone else? Answering that question honestly, that will guide your strategy and ultimately your success.